and welcome to the show, Girl Let's Talk. And of course, to those whom we have not met on other shows, it's compliments of the new year to you. I hope you have a wonderful year ahead of you. So today we're going to be talking about the second SI that was gazetted this year by the President, speaking to the protection of children and young persons. And today on the show, I'm joined by a lawyer. She's also a young person. Her name is Amanda Phiri. Welcome to the show.
Thank you very much, and compliments. The new season to you too.
Yes, thank you so much, and I hope you will have a great year as well. So, Amanda, let's jump straight into the SI that speaks to the protection of children and young person. Maybe let's start off with the background. What has been happening? Why did we end up having this SI?
All right, thank you so much. And I think it's a piece of law that got people really rattled, and newspaper article writing all these headlines, you know, and people were really worried. But I think when it comes to law, we need to think about it in with a causal link, you know, something leads to something, something leads to something. So if we all remember, in 2013, we enacted a new constitution, right? And this constitution gave us a wide range of rights. And some of the rights that we find are children's rights that are in section 81 of the constitution, right? So this section actually defines what a child is by saying a child is a boy or girl aged below the ages of 18, right? And then the same constitution in section 2 will talk about it being the supreme law of the land, and no law that is inconsistent with it can stand, or it becomes invalid to the extent of its inconsistency. So with the law coming into force, with the constitution coming into force, we then had conflicting laws that relate to children. So I think if you remember, there was the Mutsuru case that invalidated the Marriages Act as it relates to children, where it allowed a 16-year-old to get married, whereas the constitution was saying 18, and that law had to be changed. And then you see a reaction as well, someone saying, but we have a criminal code that is supposed to protect the children, you know, in terms of issues to do with sexual exploitation. So in 2022, there's a lady called Diana Eunice Kawenda. So the case is actually called Kawenda, the Kawenda case, who approached our courts and said, you know what, we have a law that's supposed to protect children. But when you read the law, the criminal code in terms of section 70, it's not protecting a certain group of children. So there's there's discrimination. And when we then went to look at the criminal code, it defines a child or young person as someone below the age of 16. So it meant that it left out 16-year-olds, 17-year-olds, and 18-year-olds out of the protection of the law when it comes to issues of sexual exploitation of children. So Diana went to court, challenged that provision. In the High Court, she did not succeed because the court then looked at other issues that were not the question before the court to say, is it a valid law? Is it constitutional? You know, so she then took the matter to the Constitutional Court, where she sought to invalidate section 70, 73, 78, 83 and 86 as it related to children, because the main concern was constitution is supreme, and it says a child is anyone below the ages of 18. But this law is protecting those that are below the ages of 16. So there is a violation. This law is not consistent with the constitution, and also it's leaving out a certain group without any form of protection. So then the court ordered that indeed that provision was unconstitutional, it was not valid. And I think there was something where it was saying the law has left children not protected. So what happened, the court then ordered those sections to be struck out because they were not constitutional. This takes us back to section 2 of the Constitution, which says any law that is inconsistent is invalid to the extent of its inconsistency. So the courts, what it did, it ordered them invalid, but then allowed them to be used for a period of 12 months to allow Parliament to then regularize the position and bring in a law that then protects children. So from 24 May 2022, Section 70, which is the controversial one that talks about sexual intercourse with children, people could be charged with that section because the law set it aside, but then it suspended, allowing Parliament to enact a new law. And after 12 months, that did not happen. So because it was suspended for 12 months, it means on the 25th of May 2023, there was then no Section 70, no Section 8. So you couldn't charge anyone with an offense of having sexual intercourse with a young person. And
wow, so that means from May 2023
yes,
up to sometime last week,
yes,
it's just been open.
There was no law,
yes,
right? But then there's something that we call at law to say a lacuna in law. There's a gap in the law, right? So this gap was then created by the fact that the courts gave Parliament time to correct the law so that it covers all children. And Parliament then did not enact the law. So then there was that gap. So you'll notice that a lot of cases that were going to court under Section 70, the lower courts would charge someone and sentence them. So normally when people are faced with charges, right, that have to do with children and of a sexual nature, you realize that when the lower courts make a ruling, like the magistrate's court, these matters automatically go to the High Court for review so that the court also satisfies themselves that it was an appropriate charge and an appropriate sentence. So there's a matter that went before one of the judges here in Bulawayo, and the matter was going there on review. And when she was reviewing this matter, she was like, how do you then charge someone on a law that does not exist? And in her ruling, the judge made a note that when someone is accused under Section 70, which is one of the sections that this SI seeks to amend, right, stated that an accused was charged, prosecuted, convicted, and sentenced with contravening a non-existent law, and doing so is an irregularity so fundamental that the law cannot allow or condone. So there's someone who contravened the law, and
yes,
as it existed then, but when he contravened the law, it was on the 29th of May. And the Section 70 had been suspended on the 25th of May. So it literally just left it open and children very vulnerable. And that conviction could not stand because there was no law. You are charging someone with Section 70 that does not exist. Of course, it's still there in our books because the law had not been amended. But then technically, there was no such offense of sleeping with or having sexual intercourses with children or with young persons. So that is the background to say there was this gap that was realized because of the supremacy of the Constitution. And then someone took the matter to the Constitutional Court. The Constitutional Court made a declaration that it was invalid, gave Parliament time to then craft laws that would then cater for children. But then the time lapsed and there was nothing. And that was then what led to where we are today. Yeah. So
now, Amanda, the law speaks to the protection of children and young persons, and you're saying that you spoke of exploitation as well of children, and then there was this gap. Let's talk about the things that happen out there. You're always in and out of the courts. You're a young person yourself. You've heard maybe from other young people as well. What are these things that young people go through when we say the young people were vulnerable? What is it that we are afraid of in this time when there's a gap?
Okay, so I think during the time when there was this gap, right, Section 70 talks about protection of young persons being engaged in sexual activities below when they are still young, or someone coming and saying, well, she's 16, she agreed for us to have sex. You know, she consented. And the Act will tell you that if someone is below the age of 16, they cannot consent, right? It changes from being rape because maybe the young person did consent. And when they come to court, they tell you he was my boyfriend, so I agreed. But the law is saying you're an older person. You cannot be having sexual intercourse with a minor who's below the ages of 16 because they do not have mental capacity to consent or to understand the consequences of their act. So you'll notice that this section does not define it as rape because rape is non-consensual. But where young persons can consent, the law is saying even if they consent, it is a crime. So now we had a situation where a young person could consent, but it was not a crime because the law books did not cater for it. Of course, the under 12, there is no issue of consenting. Even if they do, it's still considered rape. So the younger ones were protected because at least even if they consent, it's still considered as rape. But young persons, maybe 12 to the 16th that was there, even if he comes to court and says he was my boyfriend or whatnot, the courts then say, of course, they consented, but we cannot let it go because they consented because they are still young. So those were one of the protections that the Act seeks to address, to say children should not be exploited in that way. And when you look at Section 78, it looks at someone allowing their home to be used for people to come and exploit children. So you look at issues of, we've got a lot of vuzo parties in Bulawayo, you know, where someone opens their home and they allow maybe older people to come and then exploit young people. You know, they're exploiting them because you're saying, come to this party, you'll meet someone, they'll give you something for it, or it's just for fun. So the law is trying to cater for all these so that children do not find themselves in situations where they are exploited and taken advantage of, or someone facilitates for children to be taken advantage of.
Now, let's look at the statutory instrument that speaks to the protection of children and young persons. What are the provisions that have been stated, you know, for someone who's sitting there at home and trying to understand more about it? I know at times we also just pick maybe the interesting parts or the controversial parts, but I'd like us to go through it in case we miss something along the lines as well.
All right. So the provisions of particular interest, I'll just give a highlight from the Act, specific parts that are of interest, right? So Section 70, obviously they have put that provision to say a young person is any person below the ages of 18. So at least that has now covered our children. But also when you look at the Act in terms of Section 61, the definition part of it, in the past it allowed that even if a minor was in a child marriage, you then could not complain sexual exploitation because they are married. So the Act is now saying it has to be persons who are married and above the age of 18, which then goes back to the constitutional provision. There's an interesting section in Section 70, subsection 3, where it says, where sexual intercourse or indecent act takes place between a young person with whom there's an age difference of not more than 3 years. So this is a situation where you have minors, right, engaging in sexual activities, or where a young person and an adult who are not more than 3 years older than the young person. So here the adult could be an 18-year-old and a 15-year-old or 16-year-old, or a 20-year-old and a 17-year-old or 16-year-old. What the Act has done, the previous Act did not have this provision. This provision was at the discretion of the prosecutor to look at the age between these people. But now the Act is now specific to say there has to be this 3-year gap between the persons. And neither of them shall be charged with sexual intercourse or performing indecent acts with a young person unless the prosecutor general, after considering the probation officer's report, thinks they should charge. So previously, children could not be charged if they were found to have had sexual intercourse and they were both young. But the law is now saying if the probation officer, after looking at the facts, believes that these people should be charged, the probation officer now makes a recommendation to the prosecutor general to say, of course, normally you don't charge children or someone who is older than a child who had sexual intercourse, but they believe that in this instance, it should be done now there's that provision for probation officer to not say we don't charge all children, but they are looking at the various circumstances and then making a informed decision, and the prosecutor general makes an informed decision in terms of whether to charge or not to charge, right? And then we have section 76, which talks that it is declared that any person who, being an owner or occupier of any premise, knowingly permits another person on the premises to commit rape, aggravated indecent assault, sexual intercourse, or performing any act of indecent act with a young person, sodomy, bestiality, sexual intercourse, and within a prohibited degree of relationship, this person may be charged. So it could be your friend, and you allow them to come and they do what they do with young persons, they'll be charged with being an accomplice or an accessory to that offense. So we're now seeing that the law is extending even beyond the owner of the house, but even another person who's bringing children to be exploited. And then we also have section 83, which says any person who procures any person for purposes of engaging in unlawful sexual conduct with another person, or to leave Zimbabwe with the intent that the other person becomes a prostitute. So here we now see the law looking at issues of human trafficking as well when it comes to children, because they are also exploited, and the law wants to protect children. So there's also now this act that then what? Protects children. And then I think I'll just end with section 86, where it's permitting young persons to resort to a place for purposes of engaging in unlawful conduct. So if an owner of a place knowingly induces or allows a young person to enter or be in a place for purposes of engaging in unlawful sexual conduct with another person or with any other person generally, the owner shall be guilty of permitting a young person to resort to a place for purposes of engaging. So here, you know, right these days there are these lodges or houses that also allow young persons to come. So if someone becomes aware of that, they can actually report the owner of this dwelling to say this person is allowing young persons to come and use their place as a hostel or a brothel, and these are young persons. So these are some of the measures that the law is putting in place to try and protect children against sexual exploitation. So this SI really was looking at issues to do with sexual abuse and sexual exploitation, because what was aggrieved against as part 3 of the criminal code, which talks to issues to do with sexual abuse and sexual related offenses.
Well, yeah. Quite interesting as well, and a lot of issues covered there. But then, Amanda,
yes,
as you look at the law and maybe issues that have been raised before, would you now say that our young people are now protected, or there are still some issues that need to be addressed?
All right. I think when we look at issues to do with children or sexual offenses, you can't look at it in isolation of other issues, you know. If we're talking about issues to do with sexual offenses, obviously that affects issues of reproductive health, that affects issues of whether these children can then access reproductive health issues. When this issue went to court in the Kawemba case, one of the issues that were raised was, if we increase the age to 18, do we not run the risk of then depriving those children, because it's a lived reality that the age might be increased to 18, but you have young people who still engage in sexual activities, maybe on their own without even an adult being involved, or in circumstances where one has had these relations with an adult, and they then contract all these diseases. So we believe it cannot all be included in an act that is seeking to address issues of what? Of sexual exploitation. But maybe the lawmakers can come up with a comprehensive child protection act that is then able to look at all these other issues, and also enact laws that allow health officers to be able to offer these services to young persons without discriminating to say you are a young person, you do not need these services. And I think that was the intention of our legislators in section 70, subsection 3, that then looks at if young persons that have a 3-year gap indulge, they are not going to charge them. But then it also, if they're not being charged, it's taking away that criminal element and allowing them to seek for medical attention if there is need for them to seek for medical attention. So there is need really to come up with a comprehensive Child Protection Act, and also empowering and capacitating our healthcare workers. Because I think right now children are allowed to access some of these reproductive health services. But when they go to these clinics, they are told you are too young, you can't be requesting these health productive services. So maybe there is need for a law that really allows for these services to be made available, because it's something we can never run away from, that young people begin to experiment with their bodies, and there is also need to provide those services.
Well, you know, in the past weeks, I've been talking to young people, and I've met so many young people who are saying, I'm into issues of sexual reproductive health rights. You know, everyone is talking SRHR, and I'm happy that young people are also involved in making sure that they are also protected, and they can also access health services that will, you know, create a healthier nation, and, you know, they live longer as well. So any other information regarding the SI maybe that we might have that we might miss, that is also important? I think I also saw something about testifying in court. Yes.
All right. So normally when children bring cases to court, right, in some instances, some testimonies are not taken, some are. So when it comes to these issues of testifying in court, I think it has strengthened that children